On.
Members, good afternoon. We have a quorum, and we've also passed the appointed hour. May I now call to order the 16th meeting of this Bills Committee on Stamp Duty Amendment Bill 2012. First of all, I would like to invite the officials to enter the room and let me declare interest. I'm an accountant. My employer engages in tax consultation, including the provision of advice on the Stamp Duty 2012 Amendment Bill, but I am not involved in that service. Mr. Andrew Leung, I own property, and my companies also own property. Mr. Abraham Sheck, yes, I own property, and I represent the real estate constituency. Mr. Kenneth Leung, I own property and also engage in tax advice, including the stamp duty issue. And also, Mr. James Tian, yes, I made a declaration as what I did in the past. Mr. Jeffrey Lam, I own property, and some of the companies of which I am a director also own property. Mr. Tony Chair, sorry, speaker is not coming through. Mr. Leung Chi-Chang, I own property in Hong Kong. Is that all? Have you all declared? The administration has given a written reply on an item which has been discussed heatedly, and that is 133-1314-02. If the administration is ready, I'll ask the administration to take us through the paper. This is very useful to our further study of the bill clause by clause. This is a response to members' questions. In fact, Mr. Ronnie Tong suggested that there are persons under Cap 177A who could be exempted for getting an ID. Why can't the COE certificate of exemption be incorporated in the bill? We want to clarify that the COE is an administrative instrument issued by the Immigration Department. It is not put in the law. And if you put the COE in the bill, it will not be appropriate. We believe that according to our original wording, the bill has already spelled out very clearly the persons who are HKPRs. In terms of implementation, the IRD will look at the COE and also will check with the ID, Immigration Department, or IMD, Immigration Department, if there is any doubt. There were also members who raised concerns concerning minors or who are mentally incapacitated, who are HKPRs, and will the exemption given to them lead to any loophole? As we have explained, we give exemption to all HKPRs who buy property for themselves. The emphasis is the HKPR himself, basing on human rights consideration. Even if the HKPR is a minor or the HKPR is incapacitated mentally, the person's rights should be the same as other HKPRs. In considering the exemption, these two groups of people need somebody else to help them going through the purchasing process, and anyone acting on their behalf. Therefore, these people to act on their behalf. Therefore, these persons, the HKPRs, will be exempted. I mean, the minors and the mentally incapacitated will be exempted. But there is a need to produce proof. As for the minor, the guardian should be the parents, mainly. The Immigration Department, therefore, will ask for a birth certificate or an instrument to appoint a guardian person to the guardianship of minors ordinance. Usually it is issued by the court, the appointment is made by the court. As for a person who is mentally incapacitated, our idea is that there should be a valid court order or guardianship order issued under the mental health ordinance. We believe that the loopholes which members are worried about will not occur. As for the type 2 children, we've already explained that type 2 children are HKPRs, and therefore their rights are equivalent to anyone who is born in Hong Kong. As for whether administrative measures can be improved, we need to consider the legal basis. We need to consider whether there is any breach of the principle of equal treatment. Mr. Andrew Leung also mentioned whether uncompleted transactions would be chargeable. Now, if an agreement is annulled or rescinded, there is no need to pay the stamp duty. I mean the BSD. Any follow-up from members? One member has indicated to speak. Mr. Leung. I want to follow up on the issue of type 2 children. Say, if a minor or a mentally incapacitated person can get a trustee to hold the property on his or her behalf. Is my understanding correct? Application can be made through the guardian. Is it possible? Say if it is a type 2 type 2 child, a type 2 child is only 6 months old, how can he appoint a trustee or a guardian? Say the parents claim that their child authorizes them to buy a property or authorizes them to buy a property on or her behalf, and if that is the production of a birth certificate, do you accept that the person is not a Hong Kong PR, and therefore you will allow the purchase of property and exempt the BSD? In that case, are you not putting the cart before the horse? The Deputy Secretary, we look at the Hong Kong PR himself. If the child is a Hong Kong PR, then his right should be the same as other HKPRs. And if he wants to buy a property, since he's a minor, he needs somebody to help him. The parents are naturally the first tier of people to act on their behalf. And that is also the declaration of trust. And
呢個解釋呢就並未令人滿意，因為如果好多時點解要受託呢？點解可能係個細路仔承受咗個遺產，佢就揾咗佢嘅監護人或者父母受託，但係而家講緊一個海外嘅兒童，佢6個月。
Sorry, I think that is completely off, not addressing my question. Now, if a child doesn't have the capacity to buy a property, but he doesn't have the money, how can you say that he entrusts somebody else to do it for him? Now, our answer is that members have raised a lot of questions, and we consider whether there is any way for improvement. Now, in terms of, say, other children born in Hong Kong, they also have the same situation. And is there a need to make arrangements for trustee? We will have to consider the legal requirements in greater detail. So they will look into that and see if there is any way to address the members' concern. Mr. Leung Chi Cheung. Yes, I want to follow up the question. Type 2 children are Hong Kong PRs. Other HKPRs can also buy property on behalf of their children. I may own a property and then I can buy another piece of property for my child, and am I exempted from BSD in this regard? If I am a guardian or trustee, if I own property, then I can also buy another piece of property for my child who is a minor. This is a loophole which is bigger than anything else. Those who want to speculate on property, they can do the same. They can get a few more of these ways in order to become a trustee. So everybody can hold 5 or 6 pieces of property. Well, you need to get a HKPR who is a minor. Have you considered that? You want to be fair, then how can you deal with that? I think there are 2 things here. First, the person, say, for example, who buys on behalf of the minor, say the parent is not the owner of the property. The property belongs to the minor. And when the IRD looks at the case, the IRD requires for proof of identity. Unless the parent has 10 children, that may not be a very common case. A speculator cannot do that. We've heard the members' view, and we will look into that very closely.
Sorry, I should line up, but if it is sold in 3 years or 2 years' time, then actually that should amount to 2 transactions. Well, our starting point is that we should be fair to all Hong Kong PRs. That's our starting point. But administratively, as we said, we have some gatekeeping measures. But if members think that we should tighten up the administrative gatekeeping measures, we can look into that. Mr. Leung, how should I put it? If we make a law, but the law is fraught with loopholes, there will be a lot of consequences. Of course, I gave you an extreme example that one person can speculate on 5 to 6 properties because he has 6 children. However, if you are talking about a trustee and the requirements are not as strict as that for a guardian, if somebody is intent on speculation, of course he will try to use all the loopholes available. Therefore, I have great doubts about this law. I think you might have to amend certain provisions. Thank you. Okay, that's all from members. Is that right? Mr. Abraham Sheikh. Thank you, Chairman. I agree that all Hong Kong PRs should be given equal treatment. I think you have given the correct answer, but then you are moving the goalposts. If people don't listen to the CE and they buy in the name of a company, they have to pay. But here, they do not have to be PRs. They just have to have children who are PRs. These children may be 3 months old, 6 months old, or 3 years old. They do not have wishes to buy property at such a young age. Now, you talked about trust. In my amendments, I have stated very clearly the people who set up a trust have to take an oath, but these people don't. I think you have to tighten up the standards. You said that the IRD will not allow somebody to be a trustee or guardian lightly, but where can we see that in the law? Where in the law does the immigration or IRD have the right to refuse the setting up of trust or allowing someone to be a guardian? You cannot just say it. You have to let me know how or where you find the basis. This law is full of loopholes. You say I am making amendments which are full of loopholes, but I'm trying to tighten up 99% of the loopholes. The CE was answering me. I was saying a type 2 baby and his parents can set up trusts. But then when you refuse my amendments, you say we cannot just based on trusts. So what are you talking about? As we said many times, Chairman, we have not moved the goalposts. It's just that individuals and companies belong to different areas, and I won't repeat myself. Chairman, Article 105. Please, Mr. Abraham Sheikh. No, I'd just like to mention that under Article 105, individuals and companies are treated in the same way. No, sorry, please allow the DS to continue. Secondly, when we consider this, we did give this some consideration. We looked back at the past, and as a matter of fact, there were very rare cases of children buying property. And also, when the IRD asks for proof, the IRD does not require people to do something, but then it will only avail itself to the requirements of other ordinances. For example, the minor's guardian will have to look at the documentation for appointing a guardian under the Guardianship of Minors Ordinance. And also, the mentally incapacitated persons will have to produce court orders or guardianship orders pursuant to the Mental Health Ordinance. So the IRD will not create new matters. It will just look at existing ordinances. As to whether this should be stated more clearly in the law, we will consider it. Chairman, she has not answered my first point. In those ordinances, what are the criteria? Where are they? Where are they found? It is not just up to an official to say anything he likes. When or under what circumstances will applications be refused? Have any applications been refused? You should not just say that these are ordinances, but the IRD has to tell me exactly what is being done. I'm not trying to filibuster, but you are insulting our wisdom, even if we are not exactly wise. You cannot just say it and say this is an answer to our queries. And also, you have not answered me as to why the CE can have confidence in the trust set up by a non-Hong Kong PR. But if a Hong Kong person declares he does not have a trust, but he wants to buy in the name of a company, he says it is not possible. And under Article 105, individuals and companies can buy property. And I'm talking about Hong Kong PRs. If we are talking about non-Hong Kong PRs, we mean the parents of type 2 babies. Let me add, talking about minors. I mentioned the Guardianship of Minors Ordinance. And in the ordinance, it's stipulated how you can appoint a guardian. Usually it is because the parents have passed away. And if in the will, the parents state that upon their death, they would like to appoint a certain person to be a guardian. So there should be some documentary evidence. As I said, In the case of minors, the first one must be the guardian. Of course, the parents are the natural guardians. If the parents are no longer there, there should be a guardian appointed under the law. As to trustee, we are looking into the frequency of that situation. We are going to look into that in detail. So it means that type 2 babies can buy property through their parents in Hong Kong. DS, anything you want to add? Just one thing. Actually, we are talking about the person who is a Hong Kong PR, not other people. Okay. The DS has said that she will follow up on the doubts raised by members. Mr. Andrew Leung, sorry, Chairman, I'd like to mention one thing. I'm not trying to filibuster at all, but I have heard the DS and I'd like to ask certain questions. In these few days, I was talking to my friends, and if it is a property, a luxury property costing $50 million, if you can save 23.5%, then you already save over $10 million, about 100 or $11 million. If you don't call it a loophole, I will find that rather strange. Nobody has to sign anything. You would not pursue the matter. And I would joke to say, look, if you give me a quarter of that, I would be happy to buy the property in your name. Isn't that a loophole? There are now intermediaries helping to queue up for a kindergarten place. And here, there must be agents who are willing to do this. I'm not going to trust you when you say there will not be agents or intermediaries. If the property agents would like to counter your stipulations in the law, they can say, if it is type 2 baby, I can buy on your behalf and I only need 5% of the saved tax. I think Mr. Alan Leong is nodding his head. Adults need a roof over their head. I think all of us are agreed here, including those who object to these demand suppression measures. However, when you want to do this, you really need to furnish a better explanation. I think members just cannot accept this explanation, including Mr. Tian. He has objected to this provision all along. I think we are not going to let you go easily. The pro-establishment camp has worked so hard to help you close all the loopholes. But this one remains, and it is a big one. You have to explain to us why you want to allow type 2 babies to buy property and not allow companies set up by Hong Kong people. Mainlanders are buying property on the peak costing $400 to $500 million. And I can help them save the tax involved and get something for myself. There is such a big incentive because a lot of money is involved. The type 2 baby cannot handle property transactions himself. So DS, I think you are just going to read the document again, but you are not explaining the issue fully. If the administration does not think of something else to do this, we are not going to filibuster. We are not trying to block you, but I don't think any legislator can support you. DS, as I said at the beginning, why is it that for minors, whether or not they are a type 2 baby, we have the same measure? As to whether we can further tighten up implementation, we are willing to look into that again. But I'd like to stress that any tightening up administratively, we have to be careful we don't create any discrimination. If they're all Hong Kong PRs and if they want to buy property, we don't want to create any discrimination. This is a very important consideration. If we can comply with this principle, if administratively we can do something else, we are looking into that in detail. Mr. Chen Kam Lam? I declare I own property. I may be involved in transactions soon. Just now the DS, how they would handle type 2 babies. But if you want to do more consideration, you have to do it quick, because you have seen queues outside kindergartens lately, and that is all because of type 2 babies, and society is concerned. We don't want to see intermediaries helping mainland type 2 parents buy property in Hong Kong. It will be such a difficult thing to handle. Anything to add, DS? We have heard the member. Next one, James Toe. Chairman, I'd like to refer to paper 133, bracket 02. Are we on this paper? Yes. Para 5, please. Here it says, the 8th line in the Chinese version. You say that your present thinking is to make use of administrative measures. You say people have to provide documentary evidence, and one of those would be birth certificate, that we understand. And then you say an instrument to appoint a guardian. When you talk about an instrument to appoint, are you talking about minors? Does this apply to minors? Is it that they must provide a trust instrument? Well, if you look at the bill, this is the part dealing with minors and mentally incapacitated people. If they need a guardian or trustee to act on behalf of them, then this will apply. But usually minors will turn to guardians. First of all, the guardians are the parents, but if the parents are no longer there, there should be other statutory guardians. And we have heard members' views about trustees, and we are going to take another look to see how many cases involve trustees. Chairman, I don't know whether the DS knows this. Under the law, it's like this. The minor, or anyone at all, may not need to entrust another person to buy property. In Hong Kong, any adult can say that I act on behalf of the minor to buy property, but actually it means the adult is giving the property to the minor, but the minor cannot hold property because he is a minor, so the adult will act as the trustee, but actually the adult is giving the property to the minor, and no trustee documentary evidence is necessary. So what are you going to do? I don't know whether the ILD would like to supplement. What is said here is that when the ILD needs to act on behalf of minor, then they will need some evidence in order to accept exemption from BSD. But this is what the ILD is saying, that they would like to need such evidence.
Now, in the paper, we mentioned that generally we need a trustee or an appointment instrument. There may not be a formal trustee. The party concerned will have to explain to us why there is no trustee, so as to vest the interest in the beneficiary. And according to the explanation, we may ask for further evidence. Suppose it's a gift. Would you accept that it is a gift? The ILD, it depends on the circumstances of the case. Say, if the trustee has no relation with the beneficiary, then we may require more evidence. We have to look into that trust. A trust is a trust. Is a gift. Is a gift. You need to be satisfied that it's a gift. Is it a child born out of outside wedlock? Or has he killed his father? Therefore, he gives the property to the child as a gift. He say a trust is trust. I don't need to explain it to you. or there are many stories. Now, he was a sniper during an incident, and the child is a victim. Therefore, he used his retirement, his pension to buy a property for the child. You ask for an explanation, or you ask for a reasonable explanation, or you just ask for a trust deed. Otherwise, you may be criticized for discrimination. It depends on the circumstances of the case. It depends on the fact of the case. And if the fact is considered to be rare in the ordinary circumstances, then we will have a lesser probability into believing that. You mean it will only be effective if the trust deed is if the trust is probable? I've never heard of a trust deed which takes into account probability of the truth, or whether the question is whether the trust is valid or not. Now, if a trustee wants to go to the director of Inland Revenue and claim that the property was bought on behalf of the minor for exemption of the BSD, he has to provide evidence to the satisfaction of the director so that the director may give the exemption. The director, in dealing with the application, will ask for relevant evidence to satisfy him. Mr. Toh, let her finish first. You have a chance to follow up. Now, she has misunderstood the question. The IRD, in dealing with the matter, will have to look into certain documents. But what sort of documents the IRD will be satisfied will have to prove that the sort of evidence that IRD will satisfy is the evidence that prove the ordinary trustee relation. The IRD may ask for different documents depending on the nature of each case. We just give some examples of the list of documents that satisfy the director. I ask a legal question, Madam Chairman. Now, you mentioned subsection 8. It is trustee. It is not a person instructed. Yes, many people have raised their hands. I allow you to wait for the second round. Mr. Jeffrey Lam, his first round. Madam Chairman, I really hope that the bill can be passed as soon as possible, but every time there are loose ends arising, the administration says that they will go back and look into the loose ends and tie up the loose ends. When they come back, I really hope that they can give us a full answer. This time, you give us an answer to the question we raised at the last time, and now there are further questions arising from your answer. Now you say the ordinary citizens understand that. I really don't, and I feel that the members who have asked questions don't understand. And they are so smart, I don't believe they are just ordinary persons. I hope that you can produce a more detailed document or explanation so that we can have a better understanding of the matter. In fact, we seem to be repeating the same questions, but there are answers to our questions which yield further questions. I don't want to waste time in this regard, and I hope we can go straight into the bill. If we can stabilize property prices, if we can help the people, we should deal with it as quickly as possible. As for the questions raised by Ms. Abraham Sheikh and other members, I hope that you can give us a detailed reply as soon as possible. Well, in fact, they've agreed to go back and think about the administrative arrangements. I hope that she can give us a timetable. They go back to think about it. I don't know how long do they need to think about it. And when we are studying the bill clause by clause, and then they come back with an answer, and we have forgotten about it, about the thing, and then we'll have to go over everything again. This Deputy Secretary, I think the views put forward by members may affect other provisions, so we may not be able to answer the members immediately or promptly. We have already explained our administrative arrangements, and we are still considering other arrangements. Is it a point of order? The Deputy Secretary has agreed to go back and think about it and come back with a further paper on the administrative arrangements. Madam Chairman, I don't want to waste time. We can wait. We can wait for the reply. We can move to the second part. She is unable to answer our questions. After she has thought it through, she can come back with a clear answer. But there are members who want to ask for the first time, and also there is a member who wants to speak for the second time. Ms. Ann Cheng. Yes, Madam Chairman, I want to clarify this point. Say, if there is a child the child cannot hold a property, whether the person is a type 2 child or a child born to Hong Kong parents. The property can only be held through trust. And I think that's allowed. But if a property is held in trust, then one has to pay the tax in full. Many companies or many rich families hold property in trust. It gets things get complicated. A trust is a company. I think you have complicated the matter. Property owned by minors usually held by trustees, and the property is not held in the name of the child. If the property is held in trust, then will the trustee be exempted from tax? Okay, she will clarify it at one go at the next meeting. Do members want to ask any question on this paper? The Secretary has already said that she will come back with more new ideas. Mr. James Toh. Madam Chairman. Now, since we have this paper, we have to discuss this paper in detail. Therefore, I don't limit the discussion. I am disappointed. 7 months ago, I asked the same questions, and she gave the same answers. And after 7 months plus 10 days, she gave the same answer. So she has not thought through the matter in the past 10 days. I don't query whether you have thought through the matter in the past 7 months. But if she has not done so, then she still hasn't got through these questions. Hasn't gone through these questions. Now, your argument is to treat everybody, every HKPR equally, be they minor or adults. Now, there is a minor and there is an adult. An adult is a trustee for the property of a minor who is a HKPR. We are concerned that people will make use of that minor to get round the law. There are several possibilities, one of which is that they don't know each other. But even the trustee, even one who doesn't know the minor can give the property to the minor as a gift. How can you prevent that from happening? Say, whether the trust is irrevocable. If the child is being made use of, and when the property is sold, will you allow the trust to sell the property, and then the money cannot get into the pocket of the minor, the money will get into the pocket of trustee, and they will avoid tax. Of course, they may have to pay other stamp duties or other duties. Are you thinking about this? Is there any discrimination? Do you know our concern? Irrevocable trust. The trustee can sell the property and then get the money. I've been thinking about it for 7 months and 10 days. There are other measures, of course, but I'm just one person, together with my assistant, but you have hundreds of lawyers under your command. Why it seems that you have not come up with any possible answer? 10 days have elapsed, if not 7 months. Well, I've heard the members' view, but a proposal is not very simple. It has far-reaching repercussions. We don't want to create new problems simply because we change just a little bit here or a little bit there. Well, last time I asked a question on guardians, whether it is a de facto guardian or a guardian appointed through a statutory process or under common law. Has she considered that, or is it that 10 days are too short? In our paper, we already explained that as for the minors, the first natural guardian, of course, is the parent. And under the Guardianship of Minors Ordinance, the parents are not living, then there should be an appointment of a guardian. There must be an instrument. So the guardian cannot be any Tom, Dick, and Harry.
你舉100個例都可以係 OK 嘅。
Well, you can give me 100 examples, but what I'm asking you is, if it is not a court order, is it that will not be accepted? You just answer that question. Now, if it is the parents, no court order will be needed, and the parents are the guardians. Okay, I can answer your question like this. It is not the parents, but grandparents. But there is not a court order. They are de facto grandparents, and they have taken care of the child for over 10 years. Yes, the law is not stating that clearly. But if members have grave concern here, actually we are thinking of whether we should make it clearer. It might not be in the law, but maybe in the implementation guidelines of the IRD. Right, if you look at 8A, as a trustee or guardian, this is where my question arises. Are you talking about a legal guardian or de facto guardian, or would you allow both in certain circumstances? Okay, please consider those questions raised by Mr. James Toh. I think his examples should be looked into. For example, what is a gift and what is the definition of a guardian? And also, if the trustee is a company, is that allowed? All right, if the trustee is a company, if it is Hang Seng Trustee or Trust Company, and some people gives it the money to ask it to act it act as a trustee because it is my child born out of wedlock, and so I wouldn't like to be seen to be related to the child. But I have to declare this has nothing to do with me in reality. Well, no one is accusing you of anything like that. I'm just afraid that there might be some misunderstanding. I think the administration should also consider that point. Right, okay. I think those are really very good examples because guardianship can appear in different ways. Ms. Chen Yunhan is asking to speak for the first time. Yes, Chairman. I'd like to follow up on the issue of guardians. I think the DS has not made herself clear. Parents, of course, do not need to supply any evidence, but then grandparents, aunts, or even sisters. The person may not be over 18, but a sister may be an adult. But listening to the officials, I'm worried because I think you are not making yourself clear. We are quite worried that this type 2 baby provision can be abused. The people in the community are saying that huge fortunes will be made if you have a type 2 baby in your hands. So let us know exactly what is going to happen if you allow this. As you know, the law-breaking people may already have many ideas. And just look at the kindergartens. Maybe you are trying to fix many things, but then you may overlook what is important at common law. Chairman, this is exactly what the community is saying, right? Yes, they're saying that if you have a type 2 baby, you are looking to make huge gains. DS, anything to add? I think we'll go back and look into that. No, Chairman, I think you have to think about this part. I believe you should talk to your mainland counterparts as well, because they say if you have a type 2 baby, you're going to make a huge fortune. Well, I cannot foresee the problems themselves. As you know, we have different values across the boundary. You have to act with caution. Okay, you've heard Ms. Chan, right? Please consider those. Second round. Mr. Andrew Leung. Thank you, Chairman. I'd just like to mention something for the administration to consider. First of all, Hong Kong is a place with the rule of law. We have relied on the rule of law to succeed. If now you resort to administrative means, that may go against our rule of law. The trust law is in our statutes. And then you say we have the trust law, but we are going to adopt administrative means. And I think you will lose. We have to have laws instead of base anything on administrative measures. The question is, the TH Bureau is now trying to resolve problems as they come up, but I think everything is in a mess. The DOJ really has to look into this. I hope next time, if your paper is going to touch on these issues, the DOJ should come here to explain matters. Don't just entrust it to the TH Bureau. The law, as it is going to be a big joke. Ms. Chen Yunhan is in touch with a section of the community which is totally different from mine, but she has heard the same things. So the administration must be careful. Don't do something which exposes our laws to challenges. And then also, if you say you want to protect Hong Kong PRs and yet you cannot do it, this is going to be a big joke. Now, if you say minors cannot hold property, then you can debar minors, any minors, from buying property. So you close the entire loophole. However, for the sake of equality, you are opening up loopholes. Today, we talk about type 2 babies. Last time, I was talking about elderly people who have a Hong Kong PR ID card, but they cannot control themselves. They do not have life functions. So it sounds like it cannot be believed, but that is the case. So please think about the law vis-a-vis administrative measures. What are you doing here? Is that going to go against our trust law? Don't just try to tackle the issues as we raise them. You say this is a provisional law only, but we don't know. It may be here to stay. Okay, you have heard Mr. Leung. Anything to say? I'd like to reassure Mr. Leung that actually we work very closely with the DOJ. There are things I cannot answer today. It is because we rely on the advice of the DOJ. So when it comes to type 2 babies or babies born to Hong Kong people, the legal advice has said that we should be careful. We cannot just say that the parents are not Hong Kong people, so we treat them differently, because that may give rise to accusations of discrimination. Mr. Leung said maybe we should draw the line at minors and debar them from holding property. We can talk to the DOJ to see whether this is a feasible and legal way to do it. The administration doesn't want to do something which goes against the spirit of the law. I hope next time you can give us the answer, or you can actually ask the DOJ to come here to answer questions. Well, actually, we have a representative of Government Council here, but maybe that representative is only a draftsman. He or she may not be here to answer such questions of policy. Okay, our legal advisor would like to ask a question. I'd like to conclude members' questions asked so far. Sorry, the legal advisor's mic is not on. Sorry, the speaker is off mic. Sorry, speaker not coming through to interpreters. If you're talking about a certain type of trustees or guardians, well, but you now say that by making administrative arrangements, you can accept certain types of trustees or guardians. Now, next time when you come back, please consider this. Now you cast a very wide group of trustees or guardians, but if you narrow the scope of applicability by administrative means, then as Mr. Andrew Leung says, that may be ultra vires. In other words, if there is a declaration of trust, you should accept it, but that may not be aligned with what you are proposing in the bill. If necessary, you may have to amend the bill. DS, as I said, now whether the present proposal should be written into the bill, we are considering it. We do not rule out that approach. Okay, please consider the LA's views. 2 members would like to speak in the third round, 4 minutes each. Mr. James Toh, I'd like to ask about 8A, Guardian. Are you talking about just Hong Kong laws, or are you going to recognize a foreign guardian order? Do you recognize a foreign guardian order, for example, from Canada? Is that going to be okay, or should I apply for another order in Hong Kong? DS. Actually, as the LA says, we are casting the net quite widely. So we would accept foreign court orders, but of course we are listening to members. We will see where there is room to tighten up matters. This is what we are considering. And as to whether this will contravene other ordinances, we are going to look at the basic law and also the BORO. We will have to take a closer look. That is why when a member said all members should not be given exemption, now we said we have to look again whether that will be problematic. That is why we cannot give you full responses today. Mr. Toh, Chairman, if it is a foreign court order and you are going to accept it, then you will have to think carefully whether it is appropriate. And also, if you do not recognize a foreign court order, will that give rise to accusations of discrimination? Let me be very frank with you. In some places, the laws are not as strict as ours because the system is not mature. It may be easy for people to apply for a guardianship order in those places. And I'm talking about a Timbuktu court. And also, a certain official at a certain rank can act administratively to give you a guardian order according to the laws of that place. But in Hong Kong, we need a court order. However, in some places, it could be administrative in nature, but it has a legally binding effect. If that's the case, there could be chances for abuse. Of course, you need to strike a balance. You have to see whether it is going to be unfair to anybody. And also you may want to consider whether they have to come to Hong Kong to apply for a local court order. That can be complicated, but if you say that all legal institutions in the whole wide world will be given recognition, then you may give rise to a very big loophole. Okay, DS, please consider this point. Mr. James Toh, have you completed your questions? Okay, last one, Mr. Abraham Sheikh. Chairman, the DS said that she would look whether this would go against Articles 8 and 18 of the Basic Law. Well, it's clear that any local laws should not override the Basic Law. And therefore, Article 25 of the Basic Law already states that Hong Kong people should be given equality before the law. And your original view is correct, and so is mine. So this is not a question. You said you will look into it. You don't have to look into anything. All the ABCs are here. Chairman, I like to ask a question. Now, when we buy property, we have to declare the source of funding under the anti-money laundering provisions. But you do not mention this in the bill. Source of funding. It is very complicated, but you have to do that, Chairman, now when you buy property. DS? With regard to exemption under BSD, it is right that we are not mentioning the source of funding, but let me take the chance to mention again Article 25. We have explained that in a paper previously. Everybody should be given equality, but the legal advice is that it is not about absolute equality. We have to see whether a measure is going to achieve a legitimate aim, and whether that measure is really for the sake of achieving this aim, and whether it is proportionate in extent. All that should be considered. We have already explained that vis-à-vis interpretation of Article 25 of the BL. Between ourselves and the DOJ, we need some time to look into this as well. Okay, we'll continue along this line next time. Chairman, very often the administration is in the wrong, because if they are always right, we will not be plagued by this predicament, and there would not be type 2 babies. You say Article 25 is not absolute, but of course nothing is absolute except death.
Whatever case, what case you are going to bring about and show us, please do so. It is not just taxation, Mr. Lau. It's not revenue. It's not about revenue. It's not a revenue issue. Look at the Basic Law. Well, I think we draw a line here, considering this paper, in considering this paper, and then the Secretary will provide, the Deputy Secretary will give us a further reply. Let us go to clause-by-clause study of the bill. We've already finished studying Clause 7. So shall we start with Clause 8? That is C1391 of the Blue Bill, or markup copy 0019 of the English version too. So if the administration is ready, we are now on Section 29 C8. 0019 of the markup copy of the Chinese version, and also the English version too. (29CA). Page 19. Yes, please, if you're ready. Yes, thank you, Madam Chairman. We are studying Clause 8 of the Amendment Bill. Clause 8 is to amend Section 29CA of the Ordinance in respect of further provisions on special stamp duty chargeable on certain agreements for sale. 8.1 and 8.2 have the same purpose. In the original 29CA2 and 29CA3, it spells out that they spelled out that the longest holding period is 24 months. Now, with the special stamp duty, the maximum period is 36 months. So we need to cross out 24 months in this BSD provision, and then for the period of holding, it will be put in Schedule 1B. And when we go to the schedule, we will give you a detailed explanation. Since the 27th of October 2012, we have two sets of situations. The first set of situation is that you hold property from the 20th of November 2010 to 26th of December 2012. You are subject to the special stamp duty. And as for the enhanced stamp duty, it started on the 27th of December 2012. Therefore, in Schedule 2, in Part 2, property bought after 27th of October 2012. The stamp duty, different kinds of stamp duty and different rates are charged according to the time when the property was bought. And we will spell out the differences in the schedule. Here, we just amend the provision that is no longer suitable. Yes, please go on. We now turn to Clause 9. In Clause 9, we'll add two provisions, and they are 29CB and 29CC. Let me first speak on 29CB. The new 29CB deals with BSD on certain agreements for sale. 29CB1 spells out the property that is chargeable to BSD, and they are the agreements of any property executed on or after the 27th of October 2012. The details will also be in Schedule 1(1)(c). Here, it just spells out the date of commencement of the BSD. As for subsequent provisions under 29CB, the provisions spell out the circumstances under which BSD is exempted, and let me go over them one by one with you. So first, subclause 2 or subsection 2. The collector has to be satisfied as spelled out as follows. Say that the purchaser or each of the purchasers under the agreement is a Hong Kong PR acting on his or her own behalf. As long as one is a HK PR who buys a property, one is exempted from BSD. That's the basic exemption. 29CB2B deals with property jointly owned. B1 A, one or more than one person who is a Hong Kong PR jointly own the property or jointly purchase the property. That's rather simple. Now the second situation is that a Hong Kong resident jointly purchase jointly purchase a property with another person who is not a Hong Kong PR. And to fulfill the exemption requirement, the non-PR has to comply with the definition of close relative. And basically, we will explain that further. And that means parents, children, siblings, husbands and wives. Now, if the purchases, there are more than one purchases, and if one is not a HKPR, then one is still exempted if such conditions are fulfilled. Now, concerning 29 CB2A, it has to be shown to the satisfaction of the collector. Say if one claims that one buys the property on his own behalf, but he doesn't have any money. Do you have the power? And will you ask for the source of fund? Or you just ask if there is suspicion? Well, if suddenly he has he's got a sum of money within a short period of time, then and if there is reasonable evidence to show that there is a gift given as down payment, will you accept that? Now, will you ask? And will you ask just on a sampling basis? I'll answer the question first, and then someone from the IRD can answer the question for me. If a Hong Kong PR acts on his own behalf, he or she is exempted. The basic requirement is one has to satisfy the collector that he or she is a Hong Kong PR by showing the ID, and that is a declaration. Maybe the IRD can explain further. Mr. Tam? In our thinking, we have no intention to look into each and every transaction to find out the source of fund. If one claims that one acts on one's behalf, that's okay. But if there is information to indicate that the declaration is problematic, then we may conduct investigation. What do you mean by if there is any problem with declaration? You suspect that there is some problem with declaration. Say we suspect that the person may not be acting on one's behalf. The person may just hold the property on behalf of others. You don't check every case. You don't ask you don't ask every case. Correct. You're correct. Do you have the authority to ask? It is shown to the satisfaction. So based on this, you have the power to authority to ask. But how deep can your question be? Yes, the IRD, please. Under the Section 54 of the Stamp Duty Ordinance, the collector of stamp duty may require the parties concerned to produce books, accounts, and other kinds of information. Now, that is one issue in the legal sector. We have to advise our clients. Now, there was a case of HOS unit which was brought before the CFA. say the family pool the money together to buy HOS unit, but one member of that group didn't have any work at that time. In fact, one was still studying, and then in fact in that case there was the argument. It was found that the person, one of the persons was egg on trust. What is meant by egg on trust? That what one's meant by egg on one's behalf, that means you pay all the money. Maybe 1/3 is the money, 1/3 money comes from the sister, 1/3 money comes from the mother. But if one claims that it is egg on trust, is that a false declaration? Say in the future, when it comes to money, the sister may claim that the younger brother has made a false declaration. But the younger brother would say, I thought that my sister gave that part of money to me. Or did you just accept that the person, just made that declaration in good faith? Now we require that the person who makes the declaration to be in good faith. And after so many years there is a family dispute, we will not claim that the person has made a false declaration. We consider whether the person, when making the declaration, was in good faith. Now we've talked to lawyers too. Say if you are not sure whether when you buy the property with your family members, whether other family members buy that as a gift for you, we advise the person that one should clarify that, and whether you pull the money together, whether you receive a loan from your family member or what. You need to clarify this before you make the declaration in order to put yourself on a sound footing. We've heard that lawyers do make such an advice. If you are not clear about it, you better clarify the point before you make a declaration. As for the declaration, we look at the circumstances when the declaration was made. If the person made the declaration in good faith, we will not afterwards say the person made a false declaration after a family dispute has arisen. Now say, I may assume that my mother and my sister gave that part of the property to me as a gift. If say the gift is given by PR. Do you understand my question? Say 1/3. I don't hold the property on my own behalf because, in fact, 1/3 is given by my mother and 1/3 by my sister. But my worst is the situation is that they give it as a gift to me, and they are PRs. And can I still be exempted? I think with regard to Mr. Toe's case, if it is a family, say assuming the three pool their funds together to buy the property, if they are close relatives, when they buy that property together, if they make a declaration that each buy property on their own behalf, they will get the satisfaction of the IRD.
Then if 1/3 comes from the mother, 1/3 comes from the sister, and then in the end he doesn't even get the 1/3 because he will be prosecuted for perjury. But in the end, the mother and sister can act on his behalf in totality, then they will still be exempted from BSD. Well, when we first wrote this in, we had in mind the exemption of a Hong Kong PR. We want to make sure that the Hong Kong PR needs the property for his own accommodation. To tackle Mr. To's scenario, there is already the mechanism to tackle it. We do not have to state that I act on behalf of another Hong Kong PR, because that may give rise to a trust. No, let me be more clear with you. Let me be frank with you. You say that the person has to declare whether he is acting on his or her own behalf. In fact, you can change it to not on behalf of another one who is chargeable with BSD. Then it is simple and it can take care of my scenario. Do you understand me? You do not have to say on his or her own behalf. You just say you are not acting on behalf of another person who can be charged with BSD. Can you consider it? I think it is a good suggestion. Well, actually, what we have in mind is that what Mr. To has stated is already taken care of by the bill. My worry is if we open up another kind of construction, then maybe inadvertently we can open up another loophole. Mr. To said the family may enter into a dispute 10 years later. But as we said, if at the time of making declaration that person genuinely believes in what he says, then he will not be prosecuted for perjury. If a few close relatives in the family put in money together to pay mortgage payment, then they can all make the declaration. We cannot see a genuine need to include another line that you also act on behalf of an Hong Kong PR. Is that necessary? We don't want to inadvertently give rise to loopholes that can be abused. Chairman, I'll stand in line in the second round. If a declaration has to be made, you said he or she just has to genuinely believe in what is said. Now, please write this in if that's the case, because my worry is whether this will amount to true exemption of criminal liability. Now, the person may genuinely believe that the 1/3 is given to him by his mother and his sister, but then he will still be prosecuted with criminal liability. There are many parents who buy property for their children, said the chairman. Even if you buy HOS, you may have a legal problem. Legal advisor. Sorry, the speaker is not coming through to interpreters. Sorry, the mic is not on. Actually, daughters-in-law may have disputes with their mothers-in-law. And also there may be resulting trust or constructive trust, which may not be known to the persons involved at the time of setting up of the trust. These cases have appeared in our courts. If at the time of signing the declaration, the person genuinely believes in certain things, but then the court has ruled that the person may not be in the know. Yes? Chairman, let me add. I mentioned that, first of all, if the person making the declaration is not clear about matters, then first of all, he can clarify matters. Number two, the example of constructive trust with regard to an HOS, we know that the CFA has confirmed that the person making the mortgage payments has beneficial interest. In other words, if the HOS will be sold, he should be able to get part of the proceeds because he also paid mortgage payments, but he is not the legal owner. For example, he cannot make the decision that the HOS should be sold today. He doesn't have the power to do that. And coming back to Mr. To's point, how can you genuinely believe in certain things? Now, I think we provided some paper to you according to the Oaths and Declaration Ordinance. Is that the right ordinance? I have to check which ordinance it is. We will make reference to another ordinance to state under what circumstances the declaration is to be made. Chairman, I'll stand in line. Does any other member wish to follow up on this clause? If not, Mr. To, you can continue. Let us look at the wording 2A on his or her own behalf. I think this is so complicated. For example, the mother has retired and the sister does not have enough income, so the brother is included, but the brother does not make any payment towards the down payment. Now, if you ask him whether he genuinely believes it is on his own behalf, he may believe that he is doing it on behalf of his mother and his sister. Then how can he make the declaration? What does he understand the situation to be? You can say, of course, then pay the BSD then. But remember, C.Y. Leung's government says he may like to sell more HOS. That this will help people live and work happily, and a lot of people are joining hands together to buy HOS. If it is a mother and a son, it will even be a bigger problem. So you really have to think carefully how you cannot inadvertently trap people. Don't create traps. And then people will make the wrong declarations. So many people would fall into the trap. The legal advisor has mentioned CFA cases. This is quite common. Thousands of people may do this. You ask them to act with caution. What do you mean? If they act with caution, then precisely they will fall into this trap. The lawyer will advise them to do this, or else they have to pay the BSD, and the BSD is 15%. Even when they pay the down payment, it is 10% only. So how can you resolve this problem? This is so common. It is more common than redevelopment cases. When a few thousand HOS flats are sold, there will be thousands of people involved in such a scenario. DS. Well, it's still like this. Mr. To, if you are looking at bracket 2, bracket A, first of all, he himself must be a PR and he is acting on his own behalf. I think the intent of the policy is that you buy property, you must be the one buying the property. Why do we say you act on your own behalf? Because we don't want him to get the exemption when he acts on behalf of another person. That is why we like to put in the policy intent here. Talking about HOS, we said many times that we can deal with that. If it is HOS, in fact, it is relatively simple because the applicant must be a Hong Kong PR. As for constructive trust, I think we answered that already. At the time, let us again use HOS as an example. The family may involve itself in arguments many years later. As I said, at the time of declaration, if you are not clear, then you should clarify matters. But later on, if a new scenario arises and things are different, we will not say that you are guilty of perjury. You will not be prosecuted for that crime. So we think we can take care of the situation. That is why we don't think we should write it in another way, because we may give rise to situations which we have not considered in the original policy intent. Okay, I would just say one more thing. Just go back and talk to the lawyers. I'm not dictating what you should write, but Miss Diaz, Miss Wong, if I should be imprisoned, I will cite your name. I will say, I listen to you. As you know, a mother and a son can join hands together because the mother does not have enough income proof. The son will say, oh good, so you are giving me the property and I can sell it on my own behalf. But then there is another person who may think that the flat belongs to the mother, so he will be acting on behalf of his mother. Are you following me? The thing is, if he has more morals, if he genuinely believes in something, then many years later he will give a statement and then he will be trapped. He will be trapping himself and the police can take him to court. Do you understand me? Yes, I follow you. Okay, go back and try to understand the issue, because the member just doesn't want members to be entrapped innocently. Especially the source of funding for buying property can be quite diverse. Please go back and look at this. And also, Ms. Chairman, according to Ms. Agnes Wong, by acting on your own behalf, even if you do not have beneficial interest, as long as I genuinely believe it, I can act on my own behalf. But that is ridiculous in law. If you believe you have a beneficial interest, then you perhaps have a criminal mind. When you make the declaration, if you buy in 1/3, half, or all the interest, then you will have to believe that it is all yours before you should make the declaration. You should genuinely believe that you have interest. That is a different mindset. I am a lawyer, and I must tell my client that you must believe you have a beneficial interest. And secondly, you must genuinely believe that it belongs to you first. And in certain scenarios, the HOS will not be exempt under BSD, and 15% BSD has to be paid. And also, we are talking about future household arguments. And then by the time the mother may have passed away, and then you have to go to court to see whether the flat belongs to the mother, and then a distant relative would like to get the property, and in the end, after the court case, the son may go to jail. It can actually happen. It is not as simple as you think. Okay, please go back and consider the members' view. Anything to add now? No. Any other members who would like to speak? Legal advisor? Okay, if there is nothing, the DS, if you are ready, please carry on. Yes. 29 CB, bracket 2, bracket C. B is about closely related people, and C deals with, let me see, assignment or transactions amongst close relatives, and that is if the purchaser or purchasers under agreement and the vendor of each of the vendors under the agreement are closely related, then they can be exempted to pay PSD. What about the definition of close relatives? Later on, under bracket 13, there is a definition, but we just follow the definition under ad valorem stamp tax, meaning parents and children, etc. Mr. To, Chairman, let me see if I have got it right. Let me now talk about close relatives. If A and B go to buy property, and they do not enter into agreement whereby when one dies, the property will go to another. Now, one of them is a Hong Kong PR, the other one is not. They are not closely related. So should they pay half BSD? Should each of them be responsible for half of the BSD? Can the ILD please answer the question? And how is it different if the nature of the agreement is different? Okay, let us say it is not an agreement whereby when one dies, the other one pays the entire tax. Mr. Hong, the Deputy Commissioner for IR.
Mr. Tam, if the instrument is chargeable to BSD, it will be the full consideration. So if it's a joint ownership with a non-PR, then it's for the whole agreement. Say, for example, a unit, 18C Taikoo City, Taikoo Shing. That is a non-PR, liable to BSD. He buys half of the unit. So the BSD will be chargeable to half of the unit. Another PR buys the next half under another deed. And the deed, therefore, is not chargeable. Why? If the two together will have to pay the whole the stamp duty for BSD for the whole unit. I want to ask you a question. Concerning the two persons, are they close relatives? No, they are not. Say, for example, spouse, two sister and brother. The brother is Hong Kong PR. Oh, no, they're exempted. Say they're lovers. Okay, lovers. Lovers. Even if we have yet to get married, we can still buy a property together. I buy Tai Kwu Shing, a unit in Tai Kwu Shing. We put our funds together. I'm a PR. My lover is a non-PR. We buy a property under one deed, and we have to pay the full BSD for the whole deed. But if we buy, say, for example, the lover is able to buy half the unit, and then I buy the other half, then the lover will pay half of the stamp duty. Say if I buy the whole unit, and then I give half of the unit as a gift to my lover, then I only pay half. We only pay half of the BSD. So why is there a difference? What is your policy consideration? Maybe the IRD can explain. What is your consideration? Full full unit or half of the unit? What's your answer? What's your policy consideration? We don't want to have a non-PR buying property by adding the name of a PR in order to cut the BSD burden. But having heard my explanation, Ms. Wong, will you consider this? This is not to water down the harshness of the measure. From a technical point of view, shouldn't you just charge BSD on the half that is owned by the non-PR? Now, there will be a lot of problems. Have you considered this? Well, I think I have to talk to the IRD concerning just charging half of the property. Is there any problem if it is tenancy in common? If it is tenancy in common, there's even more. Or joint vis-a-vis joint tenancy. My concern, say for example, if I say I'm suffering from terminal disease, or rather my family as a member, say my father has a terminal disease and he will soon die. Then I can get somebody from the non-PR and then jointly buy property with him, and then that exempts the BSD. And then they can get around it. Yeah, please go back and think about it. Okay, let's go on. 3, subclause 3. Or subsection 3, that's about the adding names and then deleting names from the agreement. Say if a chargeable agreement, say original agreement is made in respect of any residential property, and another chargeable agreement for sale is made in respect of all or any part of the property, under what circumstances can it be exempted? Under 3A, if a name is added, say the newcomer should either be a Hong Kong PR, even if the newcomer is not a Hong Kong PR. If the newcomer is a close relative of the purchaser who is a Hong Kong PR, then the newcomer will be exempted from BSD. Yes, please go on. Now let me mention in passing under 3A2B in the English version we'll have a technical amendment. The person
original agreement as a purchaser or purchasers and the newcomer or newcomers are closely related.
Here we have a grammatical mistake. We change a purchaser to the purchaser. That's just a technical amendment, a grammatical amendment. Okay, please go on. 29 CB 3 to 3B rather. That's say under 3B1 or 3B, the purchaser under the second agreement is one of the person's name in the original agreement as the purchasers, and that the second agreement purchaser is Hong Kong PR acting on his or her own behalf, or that the second agreement purchaser is not the Hong Kong PR, but the other person or person's name in the original agreement is the purchaser or purchaser, and the second agreement purchaser are closely related. And C is also about the deleting of the names, so to speak. Now, after deleting a name, the property is still owned by more than one person. The persons are either Hong Kong PRs or each of the second agreement, or the other person or person's name in the original agreement is a purchaser or purchaser, and the second agreement purchasers are closely related. So either all Hong Kong PRs or the one is a close relation, close relative of the other, who is a PR. 29 CB4. It is about Hong Kong PR who has to buy a replacement property. Now we mentioned that before. Say under certain circumstances, a non-Hong Kong PR a Hong Kong PR does not want to sell his property and buy a new replacement on his volition. And under the special circumstances in which he has to sell and then buy a new one, not of his own volition, we will give exemption. And we've spelled out 3 scenarios. And in response to the views of the deputations, we add 5 more scenarios, and they will be in the CSA. Let me speak on the 3 situations first. First, the original property has been purchased or otherwise acquired by the URA authority for the purposes of any of its projects as defined in Section 2 of the URA Ordinance. When these people who go out to buy replacement property, even if they are non-PRs, they are exempted from BSD. The second scenario is that the property is resumed under the Land Resumption Ordinance. The Senior Council has decided to resume land for public purpose. The person therefore is forced to sell, and when he buys another property as a replacement, he is exempted from BST. And then the third scenario is the sole pursuant, the property is sold, the original property is sold to an order for sale made by the Land Tribunal under the Land Compensation Sale for Redevelopment Ordinance. These are for public purposes, that the property is sold out of the volition of the owner. The owner is therefore forced to buy a new one in replacement. And therefore, we give exemption on BST. Originally, we spelled out these three scenarios. When we move our CSAs, we've already said that having heard members' views or having heard deputations' views, there are other scenarios in which property is resumed for public purposes and the owner is required to buy a replacement. And these 5 items include the MTR ordinance, the CE for the purpose of building the building railway, operating railway, or for ancillary purpose will have to resume land. The second is resumption of land for construction of roads. The third scenario is also related to the railway. It's Section 16 Railway Ordinance. Land is resumed for railway development and related matters. And the fourth exemption is land resumption, possession of property, resumption of land for public purpose, and finally, drainage, land drainage ordinance. Say, if the drainage authority has to resume land to conduct projects, then land can be resumed. These 5 extra conditions or provisions are added upon the request of the deputations. In fact, these scenarios, 5 new scenarios, are similar to the 3 scenarios in the bill. The owners are forced to sell property under the law. In fact, they don't want to sell it, and therefore the owner should be exempted from BST. Yes, Mr. James Tow. Concerning 4B, you use the term replace. I don't know what replace imply. Say, suppose the administration just resume 2 square feet of residential property, and then I buy a 2,000 square feet property. That's not replacement. 1,992 square feet should be chargeable to BST because the government just resumed 2 square feet. Say, for example, the drainage authority may just want to resume a piece of land to put up some scaffolding. And the 2 square feet for residential is being resumed. Then can I use it as a basis to buy a 20,000 square feet land as replacement? And I don't know the time frame. You don't mention the time frame here. Say, 80 years ago, my piece of land was resumed. I bought the property after the implementation of the BST, and there was no time frame. But in fact, there is a time frame, you may say. You have it in your mind.
What's more is, for example, I can predict that it will be resumed, but then I would think that it's still okay. The property is still attractive. So I would still buy it. But then, too bad. According to B1, the URA board, for example, URA, and I belong to the URA board, I declare interest. It will resume it 3 days after I have signed the agreement. But I'm sure they are going to do it. However, if I first buy it, then it is not a replacement because I would simultaneously hold two property. Therefore, if you say it must be a replacement, this kind of scenario can happen. I'd like you to go back and think about it. Or is it that you have already thought about it? But are you sure about the implications, including time and the order? I'll ask this question first. And also, actually, in responding to the deputations, your response was, well, according to Mr. To, there is no limit to the area, but in fact there is no limit to the price and also time. I need you to think about another thing. Sometimes it happens. The URA, the resumption authority, may do this to a flat owned by a Hong Kong PR and a non-Hong Kong PR together. And when purchase is made, the non-Hong Kong PR, who is the younger one, may not be closely related to the Hong Kong PR. And it is said that in the end, the young one will own the property, so why don't you be the buyer? It happens. If that's the case, this is not allowed because it seems you require all purchasers to be in the same category. Do you think there will be a lot of abuse? Now, of course, we can understand it if a third party who is unknown comes up. But in the resumption process, if one of those buys property, can you still consider it as replacement? Go back and think about it and whether a lot of abuse will take place or else some misery will be caused. DS? Actually, we said that we could allow exemption to be given to such scenarios because the owner has never thought of moving, but because of the other ordinances we mentioned, in the case of the owner being unwilling, he is removed. And if he is a non-Hong Kong PR and he is asked to pay the BSD when he buys another property, then policy-wise, we think exemption should be given. So, indeed, we are not saying that if you own a 200 square foot unit, you can only buy a unit of the same size, and whether you should buy within a year, because you don't know. People may not be able to buy a replacement property within a year. So it's unreasonable to compel people to buy within a certain time, and the person can opt to live with relatives. That is why in terms of timing, price, and area, there are no restrictions. On the other hand, if I live in a very big property and now I move to a smaller one, I don't think it is reasonable to place any restrictions on the price. What about the sequencing of actions? The property may not be acquired by URA as such, but people may buy in advance, in anticipation of resumption. Well, yes, if you guess that certain things would happen, then you may not be eligible. We are only thinking of people who are not going to replace property on their own volition. But if it is done according to your own will, then no, Chairman, you have to understand how URA acquires property. If they use the word acquire, then it means you are selling. But if it is resumption, you will have to move out within 3 months. And it is not possible for people to buy property within 3 months. Is it that once the URA announces the redevelopment plan or acquisition plan, then it should start to count? Is that right? Well, after announcement and in actuality resumption takes place, then people should be eligible. Right, in a more reasonable approach, I think once announcement is made, you should allow the exemption. If URA wants to redevelop a block, always there will be a gazetto notice. We need to have a definite line drawn for resumption for redevelopment. But if URA only acquires property for other purposes, if it is not in accordance to Section 2 of the URA ordinance, well, the chairman talked about announcement of redevelopment, but there may be a year before actual resumption takes place. The owners would be so unsettled, and also the property may well be quite dilapidated. And after a year resumption takes place, can you rebate the BSD? You go and ask the URA. If it is official acquisition, the time frame will be very small. The time lag is very short. You need to have a more people-oriented approach. I think you understand Mr. To's view. Well, as far as I understand, but I dare not say. Between announcement and gazetto, there may be some time difference. But to me, I think once announcement is done, people should be eligible for exemption. Please consider it. Mr. Ibrahim Sheikh, is it that you have a follow-up? I'd just like to tell you, once URA announces a plan, the URA ordinance has been executed. At least there should be 80%. If it is 80%, it should be voluntary. So in B1, you should include the scenario painted by Mr. To. Secondly, in all districts, there are different agreements relating to the same block. Now you talk about demand control or suppression, then one block may involve 4 transactions. That is quite common. Out of 100 flats, the title could be for 400 persons. You have to recognize this one. Mr. To, Chairman, there is another scenario as well. Sorry, I don't want to say this, but if URA announces a redevelopment plan, the small flats would be benefiting the most. I can acquire a much more expensive property, which is going to be replacement for a URA project. Then I still do not have to pay BSD because that is replacement. So really, I beg your pardon, these are very tricky issues, but you have to think them through, or else those who are involved in URA developments may now want to buy expensive property a few months in advance of resumption, and they still would be eligible for the exemption of BSD. However, in the end, we will be taken to task, and therefore the balance is going to be very delicate. DS? Well, I agree that the balance must be carefully struck. Why we cited the examples we did? Because we hope that in the process of resumption, now we said that it is either for public purposes or redevelopment purposes. So the replacement property is given lenient treatment because we want the resumption process to be smooth. Also, those who live there, now I'm not talking about those who have ulterior motives. You have to think about people who live there, who have their property resumed and have to buy another property. So we want to exempt these people. In drafting the bill, we have thought about that balance. That is why if people strategize in advance, it means they have done their own sums and they should not be allowed the exemption. However, if they have the property resumed for public or redevelopment purposes, then it is our view that we should give them exemption. Okay. DS, please consider the other scenarios, including timing, price, and area. Because apart from the URA, we have MTR, CL, and other public utilities which may have to resume property. Please think about of all the relevant arrangements. Chairman, there is another one. This is about interpretation. In fact, if you look at tunnels, there are a few different possibilities. The entire property may be resumed or part of the property may be resumed. Sometimes they talk about land rights or easement rights, and I'm really baffled. Say, if land has to be used for the Western Tunnel, and if Gazetto notice is given, that part of my land rights would have to be resumed, and actually it's just a right of way. However, if a right is resumed on my piece of residential land, does it mean that I have lost some part of my residential property? If that's the case, I stand to gain. In other words, there has been mandatory resumption, and I'm only talking about land rights. And then I would go and buy a luxury flat, and I would save huge amounts of BSD. I'd like to ask you whether this is going to be the case, and whether the definition can rule out these scenarios. Tell me yes or no. And I'm talking about underground rights. I don't live underground, but, well, MTRCL always resumes underground rights. Yes, the land is for residential use, but people lose part of their rights because the underground is resumed. I can argue that I have lost property. It may be 1% of my land rights. Can I then buy a replacement flat? DS? Do you need to take it up with the DOJ first? I would go back and clarify matters first. Okay, the same goes for public utilities and MTR-CL resumption. All right, give that the same consideration. It is now 4:30. Is it that there is another meeting in this room? Or can we extend a little? There is another meeting going to take place in the same room, and time is up for this meeting. I think we need to adjourn here. Thank you very much, officials, for coming, and also for members' forbearance. The clause-by-clause examination will continue next time. If the administration has new papers for the next meeting, we'll discuss them. Thank you very much. The next meeting will be held on the 18th of November, on Monday at 10:45 in the morning. Please block your diary. If there is nothing under AOB, the meeting is adjourned. Thank you.